All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you very much. Mr. Kigen-Katwa, it was your turn to address the chamber. We're in public session. I suppose we should go back into private, or can you safely speak to the matter in open session?
I'm okay with addressing it in open session, Mr. President.
Prosecution, do you see any difficulty with that?
Just want to make sure that Mr. Kigen-Katwa remains within, his submissions will remain within what can be said in a public session, if need be.
Thank you. Mr. Kigen-Katwa, proceed. I take it you're mindful of your obligations, especially, I take it most of your submissions will, in any event, be a question of, on the matter of the principle, isn't it?
Yes, Mr.
Thank you very much. Sorry. I've been reminded to adjust the announcement made in the morning. I hope it is not inconvenient. We are bringing back 30 minutes into today's proceedings. We had said before we would be adjourning at 3, but we would go until 3:30, unless there's great inconvenience that's been caused. Okay, I see. Thank you. Please proceed, Mr. Kigen-Katwa.
Mr. President, we would want to have these proceedings conducted in open sessions under the provisions of Article 68, and we very much insist on them. It is our contention that the prosecution have not demonstrated adequate grounds to justify the need to give the type of protection to the next witness as they have asked for. Mr. President, the argument that the efforts that surrounded the testimony of the first witness are a reason why the type of protective measures asked for are justified, we submit, Mr. President and Your Honors, is wholly speculative. And we submit, Your Honors, that the right of Mr. Sang to trial in the open should not be taken away on the premises of speculation as propositioned by the prosecution. Mr. President and Your Honors, it is evident that the issue of the protective measures, and more specifically closed session, asked for in respect to this witness did not come from the VWU, but was actually at the instance of the prosecution, who say that in the course of their meeting with the witness, this issue spontaneously came up. And we think it's a very significant thing, Mr. President and Your Honors, that the VWU, in the course of arranging to bring the witness to this court and to make other provisions surrounding his stay, had not raised that issue until the prosecution, in their own words, obtained that spontaneous desire for that closed session. And we think, Mr. President, that that's a significant issue that should be taken into account. Mr. President, I would ask, there are two issues which I would like to raise in a closed session in my submissions, Mr. President.
We will go into closed session to do that, but before we do, on the last point you raised, it's not clear to me about the sequence of the meeting between the prosecution and the witness as one element of the sequence, and the second one being the meeting of the VWU with the witness as the other element of the sequence. It's not clear to me in what sequence that comes, but it doesn't really matter what sequence is engaged. For me, the question is, if the VWU have made their own professional assessment and acting in good faith, we must presume they are, make their recommendation, does it matter then that the witness may first voice that request during a meeting with the prosecution? In other words, are we to ignore the assessment of the VWU and their recommendation on that matter?
Mr. President, it is our submission that the genuineness of the concern of the witness is an issue to be taken. I mean, if the witness was really concerned for his protective measures, it would be expected that he would make that indication at the first opportunity. And that first opportunity includes when they made the VWU for purposes of being brought here. On the other hand, when that idea of the scope of the protective measures comes for the first time from the prosecution, and Mr. President, we reluctantly accept that the VWU are acting in good faith. We can make that concession, so I say reluctantly. But we can't say that about the prosecution. And so when it comes from the prosecution, Mr. President, we are hesitant to say that there wasn't a good faith around that issue when, according to the prosecution, it came up spontaneously in the course of proving, Mr. President. That is the distinction we wanted to make.
We must presume good faith on the part of the prosecution as well as good faith on the part of the defense. That is how we operate here. I thought I should rectify that. Unless you have specific reason to impugn the good faith of somebody else, we should not presume bad faith.
Mr. President, if you say we must, then we must.
Please proceed. You want now to go into private session?
Yes, Mr. President.
Then we go into private session.
Nous sommes en audience publique, Monsieur le Président.
Mr. President, we are in open session.
Much. The chamber will now issue its ruling on the prosecutor's application for protection measures for witness 268 during the course of the testimony. The prosecutor's application, backed up by the recommendation of the Victims and Witnesses Unit, is that the peculiar circumstances of this witness recommends that the testimony of a witness be conducted entirely in private session. The chamber has had submissions from the parties on the matter, including from the Victims' Council. The chamber has considered the submissions and the applicable law on the question, and the chamber's ruling is as follows. The chamber does not accept that the witness's testimony in its entirety will be conducted in private session. but the Chamber does accept that there are peculiar factors relating to this witness that require protection measures to be ordered. The Chamber will therefore order the usual measures, which would be voice distortion, image distortion, use of pseudonym, and use of private sessions for testimony that have a high likelihood of revealing the identity of the witness. There has been a debate in private session as to the limit of the use of private sessions where need be. The Chamber will now go into private session briefly to make a ruling in that regard.
Nous sommes en audience.
Officer, Mr. President, we are in open session.
Thank you very much. Mr. Garcia, you may proceed. Sorry. Mrs. Steinberg, I misspoke. You may proceed. Please be mindful of Article 72 in your submission, so we are not discussing that sort of thing in the public session.
Thank you, Your Honour. I don't think my reply will touch upon any of those issues. Just perhaps for the sake of the gallery who may not know what we are about, I will briefly respond to my learned friend for Mr. Ruto's request this morning for the limited excusal of Mr. Ruto from attendance next week, Monday to Wednesday, in the light of the ruling of the Appeals Chamber this morning. In the first instance, Your Honours, I note that the prosecution's insistence in upholding what it perceives to be an important, if not a fundamental, principle of law and interpretation of the Rome Statute has, in some quarters, been misinterpreted as indifference, if not vindictiveness against the accused, which most assuredly is not the case. The prosecution is accordingly grateful that the Appeals Chamber has vindicated its position in its decision this morning. However, we do also note that the majority of the Appeals Chamber has stressed the importance of maintaining a degree of flexibility in dealing with the issue of the continuous presence of the accused in court. The prosecution also notes that the accused has, to date, attended the proceedings faithfully, notwithstanding substantial pressures in his home country. The prosecution notes the limited nature and duration of the extension which is being sought, and the fact that the next two witnesses are already in The Hague and ready to testify, and we have a limited time left in which to deal with these witnesses. The prosecution also notes that, rightly or wrongly, the defense may have anticipated a different result to today's hearing, which, as my learned friend has already explained, is why he didn't bring this application sooner, rather than on the eve of the excusal, as it were. Therefore, Your Honours, in these exceptional circumstances, or shall I say on this occasion and exceptionally, the prosecution will not oppose the request for excusal. However, Your Honours, there are a number of important caveats and reservations I would like to be heard on. And perhaps first is best to deal with the proper interpretation of the decision. And my learned friend referred to paragraph 50 of the decision of the majority, well, in this case, unanimous decision of the appeals chamber. No, I beg your pardon, this was the decision of the majority. And he quoted the fact that the majority considers that the interests of justice and the psychological well-being of witnesses would not be served best if the trial had to be automatically adjourned in each instance. Now, what my learned friend, with respect, did not or omitted was the previous sentence, which we say is very important. And the previous sentence reads, during the course of prolonged criminal proceedings, unforeseen circumstances may arise, necessitating the absence of the accused person on a temporary basis. And I stress the words unforeseen and necessitating. The second observation I have to say in respect to this paragraph is that in the absence of unforeseen circumstances necessitating the absence, the alternative to excusal is not necessarily an adjournment, but of course the continued presence of the accused pursuant to an order by the court to that effect. So,
can you take that again?
Your Honours, yes. Perhaps I didn't express that eloquently enough. The quote which my learned friend read out is, and I'll read it then in full, during the course of prolonged criminal proceedings, unforeseen circumstances necessitating the absence of the accused person, may arise necessitating the absence of the accused person on a temporary basis. And then this is the portion which was quoted. The appeals chamber considers that the interests of justice and psychological well-being of witnesses would not be best served if the trial had to be automatically adjourned in each such instance. The point I make is simply that unless the absence is both unforeseen and strictly necessary, the alternative to excusing the accused is not the adjournment of the trial, but simply that the trial will continue with the accused present. So there is that important caveat to the excusal. So it's not just a choice between excuse or adjourn. There is a third option. That's basically what I'm trying to say. Now,
isn't what the appeals chamber really is saying? Sort of, I know parties would tend to hang on every sentence that looks good to them in a long decision, not too long, 27 pages. Isn't what the appeals chamber really saying is this, that the discretion to permit excusals does in fact exist, but that there are, should I say, a hexagon, six-sided wall that needs to be observed, within which the discretion may be exercised. As long as you are within those walls, you can exercise a discretion, trial chamber.
Your Honours, yes, I would agree with that. At this stage, I'm simply trying to correct what I submit was perhaps an incomplete statement of what the appeals chamber said at paragraph 50. If I may now proceed then to the 6-stage test, which Your Honour has correctly referred to, which appears at paragraph, beg your pardon, I believe it's paragraph 62. Yes, it's paragraph 62 of the majority decision. The concern which the prosecution had with the instant request goes to the first requirement, and that is that the absence of the accused can only take place in exceptional circumstances. And it is in this regard that the portion I've stressed in paragraph 50 is also connected. What is exceptional? We say exceptional circumstances are circumstances which are unforeseen and which necessitate, not make it convenient, not make it on a balance of convenience or something like that, necessitate the absence of the accused. So,
how does the trial, the appeals chamber, do they supply guidance on what's exceptional? What do they say about what is exceptional?
Your Honours, they do not, as far as I can see, specifically set out or give examples of what should be exceptional circumstances. The Court will bear with me one moment. I mean, they make reference to the removal of disruptive accused, and they make reference to the fact that other reasonable alternatives must prove inadequate. So there is obviously a measure of discretion which is left to the trial chamber to determine what is exceptional. But I am saying, Your Honours, that what is exceptional must be, one can not simply discard the rest of the majority's judgment and put whatever meaning one wishes on the word exceptional. I mean, it does have meanings in the English language which.
But what can it mean? Well, that's what we're trying to figure out. If we cannot rely on the discretion of the trial chamber to supply it, what would it mean?
Your Honours, the point I'm trying to make is that if one takes guidance from paragraph 50, it refers to two requirements which I think I submit are in fact instructive, and that is these are matters that are unforeseen and that necessitate the absence. These are certainly not matters that are routine. These are certainly not matters that would arise in the course of one's daily occupation. I would submit that a good example of an exceptional circumstance would be the one which we unfortunately were seized with on the last occasion, and that was the tragic attack on the Westgate Mall, I beg your pardon. Now, that is obviously something which nobody could have foreseen. It is something which gave rise to a dire and national emergency, and I don't think that any had the appeals chamber judgment come out before that incident, I think I can safely say that we would not have disputed that was an exceptional circumstance.
So then, would your submission then be this? Let us say Mr. Ruto, the Vice President, and his principal know that in 2 years' time there is an important summit that heads of state must attend, but it's in 2 years. That is foreseen, isn't it? Are you saying that an excusal may not be permitted because it is a foreseen event ahead of time?
Your Honours, perhaps that question may be easily avoided by the simple observation that we won't even get to that stage because there are two other matters that need to be attended to first. Firstly, whether the schedule can be adjusted, and whether or whether an adjournment would suffice. And those are not the only limits. Those were two matters which the appeal chamber specifically raised. So, if we know that in 2 years' time there's an important summit, these are matters that can be taken into account in my submission by the chamber and by the parties in the scheduling of the case, if it indeed is for a limited period. What I submit would fall within the realms of exceptional circumstances are, as I've said, unforeseen, emergency sort of circumstances that arise and for which the absence of the accused is necessary, such as a medical emergency is one that comes to mind. The accused has to go in for an urgent operation. That would certainly, in my submission, fall within these parameters. Now, because this is a matter which requires the discretion of the court, and because one cannot legislate for every possible eventuality, I don't think that I would not wish to want to speculate on what might and what might not be exceptional circumstances, except to say that...
But you raised it. You raised the question. You opened the discussion on what's exceptional and what is not. Didn't you?
Yes, Your Honour. Perhaps I again didn't phrase that eloquently enough. I mean, we can go on debating and putting hypothetical examples forward and debating whether or not these would or would not be exceptional circumstances. But for the purpose of my submission today, all I would submit is that in the ordinary course and in the future, the prosecution would not be inclined to accept that an important meeting that the accused might wish to attend, or the mere fact that the President wished to travel to this or that summit or meeting, would necessarily constitute an exceptional circumstance. Because as we know, and we know this from prior submissions by my learned friend Mr. Khan, that these are not exceptional. He's raised these issues as we've gone along in various filings and in various oral submissions, that this is the nature of the accused work. And ergo, not exceptional, and certainly not unforeseen. In the present...
Did the appeals chamber overrule the trial chamber's assessment that important functions of an extraordinary dimension might constitute an exceptional circumstance that warrants excusal? Did they overrule that assessment?
Your Honour, to the extent...
It has to be overruled for you to make the last submissions you made. Isn't it the case?
Your Honour, to the extent that those functions... let me get the correct words.
Or did the appeals chamber in fact say that the trial chamber did not err in making that assessment?
Your Honour, my submission would be that to the extent that the effect of applying discretion in that manner would result in the absence of the accused being the rule rather than the exception, yes, my submission is it was overruled. Not in terms, but that one cannot accept in advance and as a principle that these will in future excuse attendance on that basis alone. What is very clear from in my submission from the appeals chamber's ruling is that the assessment must be on a case-by-case basis and it must be exceptional in nature. Now, Your Honours, perhaps this argument is somewhat premature because, as I have indicated at the outset of this argument, on this occasion the prosecution does not oppose the excusal. And if any exceptional circumstances, well, we say exceptional circumstances are required, but my submission is the lack of opposition of the prosecution in this particular circumstance may provide that exception on which the chamber might wish to grant it. But of course, Your Honours will still have to apply your discretion to the matter. There are one or two other matters of practicality that I should also address. Well, I think I've already made the point that our concession on this occasion should not be read as an undertaking for the future and not as a precedent to the prosecution's attitude in the future, and I think I've made that clear. Then, two other matters. Firstly, obviously, the accused would be required to give the necessary waiver in terms of the majority's decision. And thirdly, one possible difficulty that might arise from the accused absence, which has come to our attention, in relation to the following witness. I note I am in public session, so I'll say no more than the following. But my learned friends are in possession of the statement of the witness, and they will be aware that there are references made to a person bearing the name of their client. Now, if the accused is not present in court, and I can't ask questions of the accused identifying who that particular person is, this could lead to certain difficulties. So I wonder whether, as part of the waiver that my learned friends will give us, could be a stipulation to the effect that the person who is referred to in the statement of this witness is in fact the first accused. Court will bear with me, please. I think that more or less deals with it.
Yes, I'll be crossing the next witness, and I can make that concession. He attended a rally where he saw the accused, and that's Mr. Ruto.
Thank you, Your Honours. Unless there are any further questions from Your Honours, those will be my submissions in reply.
I'm grateful, Mr. President. Your Honours, the issue is not completely moot, because it's always useful to have some clarity. And I do note that the prosecution have, in our submission, taken a proper course and not objected. But, Your Honour, a few observations with your leave. The prosecution seek to shroud that submission in the terms of exceptionally and without binding them in the future. As one would expect from any public prosecutor's office, we have a right to a certain degree of consistency. And we would expect that a principled view to such matters be adopted. Now, Your Honour, what it turns upon in our submission is precisely in the way Your Honour, Mr. President, put it, that there are six, Your Honour called it a hexagon. There's a...
With that hexagon...
six conditions.
I meant six-sided war,
yes.
with a pentagon.
Yes.
You know, we've been talking about pentagon and
Your
all
Honor,
kinds of stuff.
I was going to say we may get to octagon before the case is out, so I have to revisit my O-level mathematics.
Or sextagon.
Your Honor, but Your Honor, there are these six considerations. And I think the appeals chamber were very pointed not to seek to stifle or handcuff or straitjacket the trial chamber in its responsibility to do justice. It is what it says. There needs to be exceptional circumstances. It's for the trial chamber to decide what constitutes exceptional circumstances. But contrary to the submissions of my learned friend, it may well be the case that the constitutional responsibilities of Mr. Ruto, however you look at it, does amount to exceptional work. Now, Your Honour, it's for the bench to decide on a case-by-case basis the extent.
I thought I should have made this intervention not on your time, but on Mr. Steinberg's time, but it's never too late to make it so that it is clear. Of course, in his submission, he said in future he would not accept, or the prosecution would not accept something. It isn't for the prosecution to accept. It is the chamber that will accept. The prosecutor's limit is to oppose any request you will make, the defense, and then the chamber will make the ruling, accepting or not the application, and then we'll take it from there. But proceed.
I'm grateful, Mr. President, and that clarification is much appreciated. Your Honour, I will say for the record, the Appeals Chamber was very careful in our respectful submission not to overrule the key finding of the trial chamber, that the important functions of extraordinary dimensions might constitute exceptional circumstance. So, Your Honours, these are matters that the bench will decide in accordance with your own responsibilities on a case-by-case basis. But it would be wrong and a misreading in law, we say, to somehow read in an additional element which is not part of the disposition of unforeseen circumstances. That's put in an entirely different context. It's not seeking to be restrictive or defining, or to be an element of exceptional circumstance. And if one reads paragraph 50, you'll simply see that the way it's drafted makes that abundantly clear. It's but one example of the need for flexibility. But the fact that the appeals chamber, both in paragraph 2 and later on when they repeated it in the latter part of the decision, did not inject such a restriction is not unimportant. And I refer, of course, to paragraph 62. So, Your Honours, It seems that the prosecution have made their submission, not opposing. We have made ours. It's for the bench to decide. Moving forward, of course, we will hope that whatever the bench decide, the prosecution will always approach such matters in a principled way. And, Your Honours, I'm content, of course, to leave such matters to the bench to decide. I'm grateful.
Your Honour, may I just clarify that I misspoke when I said will not accept. What I meant was will not concede.
Thank you for that clarification. It appears that there is no ruling to be made from the submissions. Basically, what's happened is a take on the appeals chamber's decision. And the important thing is that the defense has made the request. And let me back up. When I say there's no ruling to be made, I mean it's not contentious. The prosecution does not oppose the request on this occasion. And so, to that extent, yes, the ruling is to that effect. As outlined earlier, the appeals chamber has clarified the issue as it is their responsibility to do. They've accepted the existence of a discretion. They appear to have been concerned that the way it was exercised gave the impression of a carte blanche to the accused, and were worried that that should not be the case. That's my interpretation of it. So, to that extent, in future, if these sorts of applications will be made, the chamber would invoke earlier advice to counsel. First of all, consult one another to see if the matter can be resolved. If it cannot be resolved, then you bring it to the chamber to litigate the question of the chamber's exercise of a discretion on the matter.
I'm grateful, Mr. President, Your Honours, and we will act accordingly.
As the Court pleases, Your Honour. May I just inquire on the issue of the waiver? Is that a matter which will be done in writing, or is that a matter, because I think it should come from Mr. Ruto, obviously, and not merely from counsel?
Your Honour, we've done a waiver previously. It hasn't been rendered void. The waiver is in operation. It's been properly lodged. I can repeat it here, and Mr. Ruto is here as well if Your Honours want confirmation of that.
I think you are safer refreshing it, because
Yes.
although the appeals chamber does recognize the discretion, but if you looked at it as positive, there's a little way they put it. If they've overturned the earlier decision, question arises as to whether everything else you did under the umbrella of that earlier decision has now not been up to question.
I'm grateful. Your Honours, in that case, I will file it in the usual way by the end of today.
Thank you. Is there anything else before we rise? Again, so we are left in no doubt as what has been done. The ruling is on the basis of the concession between the parties. The chamber grants the request of the defence.
I'm grateful, Your Honour. So the trial will continue as usual on Monday, and Mr. Ruto will be in attendance on Thursday morning,
Yes,
as usual.
to the extent of your application that the prosecutor conceded
I'm most
or
grateful.
accepted.
And Your Honour, before the end, I don't know if you wish me to raise it now or on Monday morning. There was another issue that I wish to raise relating to the next witness, and probably that should be done in private session. But I'm in Your Honour's hands to do it now or do it on Monday morning.
It's better to do it on Monday morning.
I'm grateful.
Yes.
Your Honour, could we go into private session with your leave for just 1 minute?
Private session.